Cassidy versus, or Jerome versus Cassidy.
Tension fills the air as Cassidy versus Jerome versus Cassidy unfolds before the judge. Three sides, one tangled lease, and a mystery woman named Donna Tope at the heart of the confusion. Lawyers shuffle their notes, the judge tries to make sense of it all, and everyone seems to agree on one thing: nothing about this case is simple. Let's step inside the courtroom, where every word counts and every delay adds pressure.
Good morning, Your Honor. Your Honor, Abby Cooper appearing on behalf of the Jeromes. Gail Rosen appearing on behalf of Paul Perez Cassidy.
Joe Lloyd, Your Honor, on behalf of Cassidy's.
Oh, boy.
You know, it's like Lloyd. He just shows up in things.
I know, everybody. There's a nice group before, and now Lloyd's here. All right. What are we doing on this? And we received, I did not grant it because I was off yesterday, but an ex parte motion to adjourn from Ms. Tope. So I've done nothing with that.
I have not seen an ex parte motion to adjourn from Ms. Tope.
Probably because it's ex parte. But just saying. But she filed, well, I don't even know if she filed it per se. She sent it to my staff. Indicated, I think, and correct me if I'm wrong, that she's on a plane, could not even Zoom in. So I don't know what that means. Wasn't going to deal with it yesterday when I heard.
She did send us an email to that effect, Your Honor.
Got it. Okay, that was the substance of the motion. All right, where are we now on this case?
Your Honor, we've spent, I think, a great deal of effort trying to settle this case on our own. We thus far have not been able to do so successfully. We've made some progress. Seem to be a few little hurdles in the way. I still think it's possible to settle prior to trial. If Your Honor is willing to take this on himself before a trial, it may be a judicious use of resources. But barring that kind of effort on the court's behalf, I think the only thing left to do is set a trial date.
The hearing opens with multiple attorneys introducing themselves, one for Jerome, one for Cassidy, and even a third lawyer for the Cassidys. The judge can't help but joke, saying it feels like things get complicated every time attorney Joe Lloyd enters the room. But humor aside, the real issue begins when the judge reveals he's just received an ex parte motion that wasn't even officially filed. Already, confusion and miscommunication set the tone for what's to come.
Mr. President.
Your Honor, we agree that we need to have a trial date. I mean, I think that'll give everybody something to shoot at. There's a couple things we need to do beforehand. We need to clean up the pleadings a bit. I think there was some pleadings that were filed in early versions of this case that aren't in this one. And we'd like, for example, 2 weeks to get our pleadings cleaned up.
You mean in terms of the...
There was a counterclaim in one of the earlier cases. I don't know that there's even an answer in this case.
Well, we had kind of postponed the filing of certain answers because the parties were working diligently to try to resolve them.
If we're going to try the case, we've got to file the answers and stuff.
Well, that's correct, but that is certainly not where we were hoping to head if we didn't have to.
I understand that.
We were trying to. Oh, I don't know what we were trying to do.
It's complicated. And the other thing that in conjunction with Ms. Tope, what I don't want to do, I've looked at their lease. It's not clear to me at all exactly even who the parties are. It looks to me clear that what she did is cut and pasted an old lease. But we might want a hearing of some sort with the court just to resolve, who the actual landlord is, whether Ms. Tope has any claims or role to play in this. I believe she does not, but I'd feel much more comfortable with a court order. And so if she's got some claim she wants to argue, bring it now.
Well, that causes some, I won't say problems, but one of the issues is she certainly was holding herself out as the, I guess the best way to put it is either manager or the landlord.
We believe she's a witness, and
Well, there's no doubt about that.
yeah, no, but if she can prove something, what I don't want to do is I don't want to finish this and then find out it's risen from the ashes. And so,
In terms of what?
her showing up and saying, no, she has a claim still. So what I would propose to do is we'll file a motion.
Well, and I don't mean to interrupt you, or maybe I do, but her claims, as I understood them, were really the landlord's claims. The landlord, however, may disagree with that.
And Your Honor, if I may refresh your memory, the Jeromes are here because the Jeromes filed a motion with the court indicating that Donna was the landlord, and the court declined that motion and indicated no, the pleadings had been filed on behalf of the Jeromes. The Jeromes were on the landlord side of this action and denied the motion.
Correct. And that, right, and in part, basically.
As the lawyers speak, it becomes clear that both sides have tried and failed to settle things out of court. They've made progress, they say, but every step forward brings new hurdles. One attorney suggests the judge personally step in before trial to mediate, a move that could save time and resources. It's a strategic play, showing both exhaustion and desperation from weeks of negotiations gone nowhere.
I want to say this. There were things that were happening that I'm not sure were necessarily in the Jerome's best interest. I'll just leave it at that.
Yes.
And involved certainly Miss Hope, and then her claims. She had certain claims, and then the Jerome. I wanted to leave open the possibility, certainly for the Jeromes, that they may have claims in some way as to Miss Hope. I think I got that. So you're looking to straighten out.
One, to get our answer on record, so if we're trying a case, here's the pleadings, here's the claims.
Correct. I mean, if we're I think a lot has to be cleaned up if we're gonna try it.
I think you're right, Your Honor. And the way that I think some of the discussion has been amongst counsel present in this courtroom is that we're looking to bring only landlord-tenant claims in front of this court for a landlord-tenant trial.
Correct.
There is a separate action in the circuit court that Ms. Tope has brought. It's an assault and battery thing that she's done.
Yes, I think she had done that.
And we have a trial scheduled in that case in May, I think. That's
May of next year.
Next year. That case.
Perfect. No.
That case is proceeding, and we will resolve it. But we don't want to duplicate stuff. And so I think if there's a landlord-tenant case that involves her, I want to know it now and be done with it. And I don't think there is. But I'd love a court order to that.
If it involves her?
Yes. I mean, something where she has a claim against my clients. I do not want that to resurface after we're done, other than what's in the circuit court. And I don't mean to be.
Whether Ms. Tope has claims as against your landlord-tenant claims.
Yeah.
So the part currently, Ms. Tope is here through Cambridge Holdings LLC. She individually is not a part of these proceedings.
Correct. Does that help you? Or no? Given the look on your face, no.
No, I would like what I don't want to have happen is I don't want landlord-tenant cases to surface in the circuit court and her say, well, those weren't addressed in the district court and I still have them. And I don't want her to refile in the district court. I want to be done with Donna. So, and I was hoping we could.
But that
motion of
claim-
some sort.
Well, and that may be part of the other issue. As I understand, just on the surface, the assault and battery that she's claiming came as a result, allegedly, of involvement regarding the tenants.
Yes.
The discussion soon shifts to cleaning up pleadings, basically fixing a messy pile of legal paperwork. Some documents are missing, others are outdated, and one lawyer even admits they paused filings to focus on peace talks. The judge listens patiently but reminds them, if this case goes to trial, every document must be perfect. It's a moment that shows how small administrative details can make or break a case.
I mean, is it a claim of her against the tenants? Yes.
Pardon? Right. Her claims against the tenants. So I don't know. I mean, I probably have to think that through a little bit more, but I don't know that it could be fully separated out, maybe you'd like it to. Because I think she's going to make or can make certain claims. However, as to whether or not those claims are proper claims, I can't say for sure. I have my doubts, but
I'm hoping we can present you with a motion that will persuade you. So, but I'd like to be just done with that with Donna as regards this case. And we can try this case fairly clean.
okay.
And I don't want it to resurface. That's my goal.
Understood. Ms. Rosen, you have been conspicuously quiet. So,
Letting Mr. Lloyd do the talking today.
what?
Letting Mr. Lloyd do the talking today.
Oh, don't do that. For my sake, don't. Okay, so where do we want to go from here?
Let's start with a trial date and that we can work against. We'll file our pleadings within by the end of next week at the latest to clean them up. We can circle stuff back and forth. With the permission of the court, we would file a motion and serve Ms. Tope and let her make her claim. I'd like to end up with an order, a final order as regards her in this court on landlord-tenant things. And we have to persuade you, I understand.
But you understand that she doesn't. There would be an order maybe clarifying what she is in this case, but it doesn't make her go away in this case.
No.
I don't see that happen.
Okay. Well, we'll get as close as we can. Then we still have to deal with the circuit court case, and I know that, and I'm not trying to get rid of that.
So in terms of cleaning up the pleadings, how much time did the parties need to get that done?
End of next week for us, please. That would be,
But then there's going to need to be potentially responses.
yeah.
So maybe why don't we look at, can everybody get everything done, even if the timelines are shortened, by the 18th or 17th of November?
Yes.
Well, say the 18th?
Yes.
Isn't that a Saturday?
We're gonna need them. I can clean up my pleadings too, because I do
Okay.
think there's,
Oh, no, it's.
so why don't I go first?
On,
On cleaning up the pleadings, because I think on the landlord side, there's some cleanup to do as well.
okay. I mean, you know,
Because I don't want you to respond to what's on there currently. I think
okay. Good.
What just happened?
I think that the landlord would like an opportunity to clean up the pleadings on the landlord side, so we should probably go first. And then the tenants are responding to the most recent pleadings.
All right. So how fast can you do that?
I can do that the week before the 18th, Your Honor.
The week before the 18th.
So that would
Then
be,
you need time to respond to that.
We
So
do.
what's
And
my
there will be a
next-
counterclaim,
Pardon?
and then we may have a counterclaim, you know,
That's what I thought.
yeah.
okay.
So, it's my next date after the 18th.
Then comes the most confusing part, Donatope. Is she the landlord, the manager, or something else entirely? Each lawyer has a different version of the truth. One claims she has no role, another insists she's a witness, and the judge isn't convinced by anyone. They discuss her possible claims, her emails, even another lawsuit she's filed for assault and battery. It's like the ghost of Donatope keeps haunting every attempt to move forward.
Okay, so if the landlord has everything in order by the 17th, any responses, counterclaims, and the like would then need to be addressed within the next 2 weeks after that,
Okay.
It's December 1st, something like that.
by December 1st. And then what I would do is I'll set another pre-trial final settlement conference December 2nd. Just because we have to make sure everything's in order. To have that. Go ahead, Mr. Mike.
If we file on December 1st and there's a counterclaim, we won't have an answer to that at that point.
Correct. Oh, I'm well aware of
Okay.
that. I mean, I get it, but if I put it further out, back on track, so that we know exactly what we're dealing with, because we didn't. Now, the one wild card in all of this is I'm not sure what Ms. Hope will do with all of this, because some of the claims, I think, from the landlord are going to potentially involve her, or maybe the counterclaims are going to. So I think it's probably better that we have that pre-trial, because she's going to, I would imagine, have to respond to some of that. If that makes any sense.
Yeah, I don't think we are planning a counterclaim that would be directly against either Donna or Cambridge as a party. Now, she may be a
Right, but the problem's going to be that the counterclaim, so the initial claim is going to involve certain things. Your counterclaim would then come,
Yes.
but then the response to that counterclaim, I can imagine, at least knowing what I know about the case, may involve some of the actions of this code.
Okay.
That's
We'll deal with it when it arises.
And Joe for
Yes.
filing the motion.
and how I've handled
That
this.
you
So,
want-
Now, so how would you visualize this interacting with the motion we'd like, just to clarify Ms. Tope's status?
okay, so what I'll do is I'll set a final settlement conference for December 2nd. Any motion you'd like to clarify the rights of the parties, I would need filed with an opportunity for the parties to respond. So you need to file that in time for them to
In time.
respond, and then I can rule on that
So you'd
On
see
that
us-
same day?
on that same
Yeah,
day.
arguing it on the second.
Yes.
Okay.
Yes.
So the second at 9 a.m. for final settlement conference and to argue any motions.
Yes. And then from there, once everything's cleaned up, then I can give you a clear trial date and see exactly
Good.
where
Okay.
that makes sense.
Thank you.
Thank you, Your
I
Honor.
really want to say you're welcome, but
No. We have a direction now. We know where
Yes.
we're headed. And
all
I-
right.
Thank you.
Thank you.
Thank you, Your Honor.
Finally, after hours of legal back and forth, the judge takes control. He orders both sides to clean up their pleadings by mid-November, file any counterclaims, and prepare for a settlement conference in December. The courtroom tension starts to ease as everyone realizes they finally have direction. "We know where we're headed," the judge says, closing the session with a rare sense of relief and order amid chaos.